Good morning. My name is Darren Richardson, and I'm an estate planning attorney with the law firm of Eastman Estate Planning here in Surprise, Arizona. And today I just wanted to take a moment to talk to you about an AB trust and whether you need an AB trust as part of your overall estate planning strategy. So what is an AB trust? An AB trust is a specific type of trust used for married couples. And at its core, its purpose is to mitigate against federal estate tax when death occurs. Back in the 90s and early 2000s, a lot of attorneys were drafting AB trusts for their married clients because the federal estate tax threshold was much less than what it is today. On January 1st, 2026, our federal estate tax threshold becomes $15 million per person. So, do you need an AB trust? Well, if you're a married couple and you have less than $30 million of combined assets, there's a high probability you do not need an AB trust. Now, I say high probability because you can use an AB trust for other reasons, such as if you are a married couple, but this isn't your first marriage, and you have children from a separate relationship and you want to protect the assets for your children when you pass away, then an AB trust may still be a good course of action for you. But if you're a married couple, first marriage, you don't have children from separate relationships, and you have less than $30 million in assets, then there's a good chance we don't need an AB trust anymore. So if you set your trust up back in the late 90s and early 2000s, and you're a married couple, there's a high probability that you have an AB trust, and I recommend that you have that reviewed by your estate planning attorney and turn it into a much more flexible trust, something that's going to be easier to administer, and it's going to provide the surviving spouse much more access and control after first death. An AB trust doesn't do that for you. An AB trust, basically, it takes your primary trust and it splits that trust into an A trust and a B trust. Surviving spouse still has full access and control of the A trust, but they do not have access or control over the B trust. And I shouldn't say they don't have access. They have limited access to the B trust for income and principal, but they can't amend the trust, they can't revoke it, they can't restate it, and they're bound by the terms of that trust. So if you're looking for flexibility, you have less than $30 million in assets, you're not worried about protecting assets for children from a previous relationship, then an AB trust probably isn't the best route for you. So I recommend you meet with your estate planning attorney. If you don't have an estate planning attorney, feel free to call our office. We'd be happy to give you a complimentary consultation. Have a good day.